Good afternoon, everyone. Thank you so much for joining us this afternoon for another installation of the Decanal programme. As many of you hopefully will know, my name is Dominique Smith and I am a barrister at Deca Chambers, often known as Dom. Today, I am delighted to be joined by Matt Gatenby, who is a senior partner from Travlaw. And as you would have seen when you enrolled to join this webinar, today we're going to be discussing all things medical tourism, as you can see from the name of the webinar, and why it's important for this topic to be on your radar at the moment. The interplay of these claims with the package travel regulations, for example, some notable cases, and points for both claimants and defendants to bear in mind. And we're going to operate this webinar a bit differently in the sense that Matt and I are going to come at this purposely from two different perspectives. So I'm going to be adopting a viewpoint from a claimant's perspective. Matt will be from a defendant's perspective. And we're doing this so that you can be aware from both sides of the coin what you should be looking for if you have any claims that arise out of medical tourism. Now, before we get into things, I'm sure you're all fully aware of this by now, but if you want to contribute to the discussion that we have, there is a chat box. Please do pop your comments in there. If you have a question, it's best to put that in the Q&A, just otherwise it can get a little bit lost. But if your question isn't answered, don't fear, it might be because we're waiting until the end to do that. Alternatively, if it's a bit of a complicated one, you'll see our email addresses are at the end, and just pop us an email about your question there. And finally, please don't use the raise hand function just because we don't know why you're raising your hand. So it's best if you have anything you want to say, just do it either in the Q&A box or the chat box. So just to give you an outline of what Matt and I are going to be discussing today, and as I said, this is going to be a general discussion on this topic. We're going to be talking about medical tourism generally, why it's important, the types of claim, as I said, the package travel regulations, and the other issues here about what we need to think about. Is it a package? Is it a consumer contract? Some cases, and we're going to be focusing on Clark and Kalasinski, and this is one that I assume is on a lot of your radars, just because of the implications it may have, which we're going to come on to. But leaving that there, we've kept the slides quite brief because we want to have a good chat from both sides about it. But it's quite a topical topic, isn't it? Medical tourism, Matt.
It is. And good afternoon from me, and thank you for having me, Dom and Deca Chambers. It's a pleasure to be here. It is very topical. I'll tell you what it isn't, is it's not new. As a phenomenon, you know, the concept of people being from the UK, going abroad to get surgery is decades and decades old. But, you know, why are we here talking about it? Well, we both, didn't we, kind of bottomed on, if that's the right word, to the fact that we're seeing it more. It's in the news more. We're seeing more cases. We're seeing it being talked about more in our kind of respective day-to-days. It's palpable. It's notable.
Absolutely. And it was interesting because I don't know if anyone else saw this. There was a Guardian article recently about people travelling abroad for surgery. And in that, it said that there was over 7 million people waiting for treatment in England alone in November 2022. And over 400,000 of them been waiting for over a year. So at the time that this coming time, we're seeing that actually, although it's not a new concept, it's something that people are turning to more and more, which is why I think both of us are having these claims fall on our desks so much more. And also that coupled with, I think, the rise of reality TV, social media, the accessibility of these treatments is just a combination that's meaning that we're seeing this rise almost exponentially, don't you think, Matt?
Yeah, and if it's the same article, I think I saw it. Isn't that the one that kind of said it's not medical tourism, it's desperation?
Absolutely, yeah. That's
so that
it.
Whole point of there is a difference between going to get your teeth done or cosmetic type stuff, and then just the increased amount of people who feel like, well, look, you know, waiting times are waiting times. I have a bit of money to be able to make this happen abroad. And again, I think this is where I'm not qualified to talk about the demographics and all that kind of stuff. There's better people than I, but, you know, people clearly have a bit more money, and the choice is there, the ability to actually do this. You know, I'm saying it happened decades ago, but that would have only been available to a certain few because the cost in terms of travel and the treatment abroad and everything, you know, would have been much higher. Now, you know, as we will get into, it's much more widely available. So it's a choice.
Absolutely. And you're right to point out this distinction between the two, because I think often when we're talking about these claims, the natural inclination is to think actually it's all about cosmetic surgery. It's about getting your teeth done in Turkey or dental treatment there. It's about having breast augmentations and liposuction. But we are also seeing this whole other aspect of just people waiting for hip replacements, for example, knee operations, which they're just not getting because of the waiting list dramas really that they're having at the moment. So they're going abroad. And I think what also makes this quite an attractive option for people is to think, well, actually, I can almost couple this with a bit of a holiday that I can recover, not just in a in a hospital, but in a hotel by the beach, overlooking the beach, or by the beach, which makes it more of an attractive option. But I think the problem that we have, as we've seen, and we're going to come on to in a bit, is about whether that then makes it a package holiday. How are we going to deal with this claim, and what perspective are we going to come at it from? And also just really then the methodology behind it. So how is the contract formed? Are we dealing with this on social media? Are there just an exchange of WhatsApps in terms of how this is agreed to?
Yeah, that's a huge side of things that we really do need to get into. But just whilst it's on the slide, we were both, weren't we, when we were kind of talking about this? Part of the reason for it was I keep using words like phenomenal and amazing, which just goes to show how easily surprised I am. But the FCDO advice about Turkey specifically is well, you tell me. I use too many superlatives. What is that all about? When have we seen something like that come up in a Foreign Commonwealth Development Office advice?
Well, I think it's quite extraordinary, actually, because I've not seen this sort of advice given. And for those who haven't seen it, it's off the back of the fact that the FCDO are saying that 22 British nationals have died in Turkey following medical tourism since January 2019. So it's quite an extraordinary step for them to take. And what they've done is they've advised essentially individuals visiting the website to go to another website which has a list of approved medical practitioners by the Turkish Ministry of Health. And they say that carry out your own research. It's unwise to rely upon private companies that have a financial interest in your treatment abroad. But I know I said this to you earlier, Matt, I don't know how an ordinary person is supposed to necessarily know whether a private company has a financial interest in their treatment, or what questions they should ask, or if there are any telltale signs. And so I'm not sure it actually goes far enough. But also, is it going to stop people? Are people going to be aware that the standard of care they may receive abroad may not be the same as that in England and Wales?
Yeah, all good points. I mean, you can make arguments left, right, and centre on this. From a lot of my day-to-day type stuff, we use, or we look at in the travel industry, the FCDO as that kind of, good piece of advice. You shouldn't travel here because there is a volcano, and mostly that aligns with what people would choose to do just with that piece of information. But it is essentially there to protect the UK citizenship. So fine, it makes sense. But now they're kind of, by giving this advice, they're starting to kind of deem certain kinds of services in certain places and companies appropriate or not. And I don't know where that ends, and I don't know how that unfolds. Again, it isn't written down anywhere, but for many, many years in the travel industry, advice on the FCDO website not to travel somewhere is usually taken as a trigger for a consumer to be able to get, a refund. How does that work with this kind of advice? It's not come up yet to my knowledge.
No.
It's not quite the same thing, I accept, but it's like at some point we're going to have to get our teeth into that.
Well, I wonder, I'm not sure how it's going to play out, because I can't see a defendant saying, you tell me, Matt, when you deal with matters such as this, but I can't see a defendant turning around saying, well, we weren't on the approved providers list, and so you took a risk, because that's a risky enough argument in itself to be suggesting that maybe you're not quite up to standard.
Yes. or conversely, and again, look, I'm well aware there'll be claimant lawyers throwing stuff at the screen saying there's more to it than that, and I totally get it, and I agree. But like, what if we were on the approved list? Is that enough to say, well, look, hey, we're on the approved list, what more can we do?
Yeah.
Bizarre.
How much onus should be put on the claimant as well? It's not something, unless you actively go and search for it, that someone's going to know. They've got to go and Google and got to go and look at to see what advice actually says. I can't think of many people going and thinking, oh, well, I've booked a a surgery in Poland, I should go and check, say, for example, if this applied to Poland, which I think at some point we might get some extra jurisdictions in there. But I can't see that then they'd say, oh, well, let me just check the FCDO website and see what it says about medical tourism.
Yeah. And actually, with this, the way that it's structured, you've got the UK government or governmental department referring to the Turkish authorities for what is essentially approved list. So isn't that at least tacit, if not express approval by both Turkey and the United Kingdom that these places are basically okay, although they do qualify it with, well, you should still check. But it's going to be deemed to mean something at some point, isn't it?
I think so. And as I said, I can't see that it won't happen for other countries.
Yeah.
It might be something, if the FCDO have taken this step, I think then they're going to be possibly keeping an eye on it elsewhere, because there's certainly got to be, it can't just be Turkey that we're having a rise of issues of British nationals dying abroad.
Yeah, but again, kind of coming back to your earlier point and also the point about, I don't know what the numbers are. 22 people since January 2019, sadly being deceased as a result of this particular type of activity. I mean, that seems a lot to me.
Particularly because we had a pandemic as well,
Yeah.
and people weren't travelling. So it seems an extraordinarily high number. So it remains to be seen what the FCDO do about it, if they make the advice a bit more stringent so that consumers know what they need to look for, or if they extend it further. But it's certainly something I think that everyone needs to have on their radar, because points could be made in respect of litigation about it.
Yeah. And something we mentioned, just last point from that slide, something
Sure.
You and I mentioned just before a lot of the people here joined, we were talking about, if someone said to us, Matt, Dom, give us a definition we can hold you to in terms of what medical tourism is, we'd both feel a little bit uncomfortable, right? And kind of like,
Yeah.
well, it's not that easy. FCDO quite happy to give a definition medical tourism refers to, et cetera, et cetera, et cetera. So
Yeah.
I find that astounding, but I do see where it's coming from. I don't want to be too critical, because they are trying to achieve a kind of social benefit here in terms of trying to make things better. So fair enough.
Yeah, and just picking up on that point, actually, when we turn to the types of claims, because obviously we all have to think very carefully about how we're going to be bringing and defending these claims. It's something that comes into play when we're talking about package holidays, because when you look at package holidays, as you all know, if you do travel work, we're looking under the PTR 2018 at the number of travel services to see if something qualifies as a package. So you're looking at, in essence, right, are there flights, accommodation? Okay, there's 2 travel services. We fall into the definition of a package. All's good. If, of course, you have 1 travel service, sometimes I find that's coming up more frequently in these claims, because providers may think, well, actually, then it can't be a package. There is a part of the package travel regulations that you need to be aware of, and that's Regulation 2, subsection 6, which I've put on the slide for you. And that's because it's essentially a caveat there where there's 1 travel service in existence. So, for example, if you just have accommodation, claimants booked flights separately, and it suggests that a package will exist if the tourist service accounts for a significant proportion of the value of the combination or is an essential feature. And when you look back at the discussions prior to the directive actually being implemented, that seems to be 25% or more of the combination. And as we all know, surgery almost always accounts for more than that. But the point then comes in as to, can surgery be deemed to be a tourist service? So this is where we go almost round in circles, because there is nothing technically that I can see in any of the previous discussions surrounding the directive, or anything that's in there, despite there being a non-exhaustive list of what may amount to a tourist service, that says that surgery is one of them.
Yeah, very much so. I have a couple of different thoughts on this, but let's start by saying the thing that everybody gets annoyed at lawyers saying about, but we all have to say it from time to time, which is, well, we're going to need cases to have the answer to this, and we don't have that yet. But look, read in very plain terms, in black and white, surgery can't be a tourist service, can't be a travel service, because it lists what they are in Regulation 2, and you just can't fit a square peg in a round hole. So my starting point on this, again, looking at it, if you're trying to defend this kind of thing, well, it can't be a package because surgery is not a tourist service. It isn't. And therefore it can't be capable of being a travel service. Therefore it can't be one of the building blocks of a package, So Dom, you and your claimant can pack their bags and go home.
See, I think the opposite. I actually think, and just like we saw in the FCDO advice, I can't see how it cannot be deemed to be a tourist service. It's something that, in and of itself, I think has to fall into being a tourist service. I can't see how it isn't. When you look at the very definitions of things, and what actually I think for claimants is a really important point, is often you will see a clinic online who's advertising these packages. And funny enough, I've put a picture in the bottom of one I found within seconds on Google yesterday. I've taken the clinic's name out of it, of course, that they advertise packages and often will say on their websites, medical tourism is really popular and we cater to British tourists and we have British speaking people here. Now, how can you not say in the light of that, or how can a defendant not argue in the light of that, well, actually, it's clearly a tourist service because we accept in our very own advertising it's a tourist service.
There is a real life element to that, isn't there? Which is you see that kind of advert a lot. Yes. And so the way that it is phrased and set up, and ultimately the way that things are sold is one of the most important things. Not necessarily in a medical tourism or whatever you want to call it context, but again, when we're talking to clients about, is it a package or not, and things like that, how was it sold? Show me the literature, show me the brochure, show me the website, whatever it is, because that's really, really important. And it comes back to that. I know we're going to talk about this, don't want to get too ahead of the game, but there in your kind of oyster picture, they literally call it a package. Well, that feels like it's important, but also isn't there just a kind of wider acceptance of this anyway? Like, for instance, you and I, we've entitled this medical tourism, this webinar, so we're kind of accepting that it is a tourist service. We're literally using a variation of the word, aren't we?
I know. I'm sure you don't want to be held to that, Matt. I won't hold you to it, but yes.
This isn't being recorded, is it? But the lawyer's answer to that will be, well, never mind that, the black and white of the package travel regulations is blah, blah, blah. But yeah, look, let's not kid ourselves. It's a bit of a thorny issue with plenty of elements to it.
Yeah, and we've just had a question from Nick. Hi, Nick. Just saying, isn't it easier to say that since the 2018 regs came in, that they encompass far more than the previous regulations in that respect? And I think if you're for a claimant, that's absolutely right. You can. And what I noticed in terms of the previous discussions when this was coming into force and how it came to be, because you can find this all out, the minute meetings and things online, is that they go so far as saying a spa treatment can fall into being a tourist service. Now, I don't think there's much of a distinction there between a tourist service in terms of a spa treatment and a cosmetic procedure or surgical procedure, because it seems to me that they're not that dissimilar. I appreciate that you may have some surgery in one of them, but if we're talking about, say, some non-surgical enhancements abroad, that's not too dissimilar from having some wraps and things and facials and the like. So I don't think it's that dissimilar at all. And I actually don't think, I may be wrong, but I don't think it will take much for a judge to make that leap either. But if you are for a claimant, what I often would do is specifically look at the social media. So, as Matt was saying, what does the literature say? What does anything say? And the problem we have with these claims is that you may find there isn't really much, that is all done on social media. Everything's advertised on Instagram or WhatsApp. How are they defining their services? So are they saying, well, we have a bronze package, we have a gold package? That seems to indicate they seem to be accepting that they sell packages. Are they saying on their Instagram pages or their Facebook pages or their clinic pages that, in essence, that they specialise in medical tourism for British nationals? Because those are things you absolutely want to be pleading. Because Matt and I had this discussion before, that actually, does this become a point in many cases? Probably not, because it seems to be that if you're advertising your services in that way, it's going to be extremely difficult for a defendant to argue that this is not medical tourism and therefore not within the definition of the package. But alternatively, the point could be made and we have no higher court authority on it.
Yeah, absolutely. It's a typical and expected on-point question from Nick. Hi, Nick. Starting with that, absolutely right. The scope of what was meant to be included in packages was definitely widened. There's no question about that. It's all there in the guidance from the commission and their intention to what this was supposed to be. I suppose if you were going to say anything on that, you would say, well, is it meant to be in a tourism, in a leisure context? And so leading on to what you mentioned, Dom, we act for any number of clients that if you said health tourism, they'd say, oh yeah, we do that. But what we're talking about here is maybe a flight and then accommodation, maybe a villa on a hillside somewhere nice in the Mediterranean or something with an expert yoga instructor or something like that. So again, at the risk of kind of sounding an expert and using phrases which are not right, more low impact type stuff. But they will say, look, this is for physical and spiritual health, etc., etc. But what we're talking about here is the further down that scale, as you say, into surgery. Now, in concept, yes, you can see the similarities. There must be a line drawn somewhere, but we just don't know where it is. But I think those businesses would accept, look, that's all part of our package. It's sold as such. So that's fine. And actually, there are businesses out there, I know this, that do sell packages which are the surgery, the tourism, everything. Goes back to that point you said earlier on, Dom. What a brilliant thing to be able to do. Have your surgery abroad and then immediately be in the kind of location where you would go to want to recuperate. It's hot, it's warm, it's sunny. You're in an environment that is set up to be able to look after you, serve you, care for you. You don't have to do the usual kind of like household stuff, etc., etc. So those things sit together nicely. Well, then let's sell them together nicely. And as long as you know what you're doing and you're happy with that, that's not an issue. So it's not necessarily people going out of their way to avoid this kind of stuff. It is going to happen, and we're going to have plenty of companies out there that are doing this. Fine, they accept it, and claims, etc., are dealt with in the normal way through the supply chain, etc., etc. But I think what we're saying here is it just seems that it's never quite that easy, is it?
No. And I suspect there will be a case that eventually picks up on this point, because I should say that Nick's just made a comment saying most of the time the contract will include surgery and accommodation. And, obviously you may see in a case where you have the two travel services anyway, where flights are included. I find more often than not now that actually claimants are left to book their own flights. And so you're just hinging on the one travel service, which is why this point becomes so much more important. But it's one of those issues that I think that we're going to see eventually in a case, because I think if there's a lack of that advertising that, I was talking about earlier, that we expect to say that this is medical tourism, and we've only got the one travel service, so we're solely relying on this point about the operation itself being a tourist service, then I think it could legitimately become an issue. But whether anyone wants to take that point to get better guidance on it is another matter.
Feels like it's bound to come up. I think we agree on that.
I think so. And it's so important to explore this right at the outset for both claimants and defendants, because there is a real issue, I think, particularly for defendants, that if they have sold a package holiday, they may not be aware of that and the implications of that. And that's something, Matt, I'll leave to you as to what the implications could be. But from a claimant's perspective, it's far easier to say, well, look, this is a package, because you then bring it within the meaning of the regs. It's a far easier claim to plead, makes a lot of your life easier, I find. The problem that may arise is if a defendant doesn't know they've sold a package, maybe that they may not have the insurance, for example, to cover any claim. And that's a point we'll come on to a bit in a moment. But I wonder, Matt, from your perspective, are you seeing a lot more instances of parties not realising they've sold a package? Yes.
And that shouldn't really happen, because these are usually companies that are well informed, are sophisticated enough. But what they're seeing is, and again, maybe this is part of their kind of rebound from the pandemic, in the sense that everyone's keen to get new revenue streams and kind of pick up after what's been, pretty rough couple of years, understatement of the year. So they're doing what comes naturally to them. They're seeing a demand in the consumer market for this kind of thing. Think, hang on a minute, traveling to Turkey or traveling to Poland or traveling anywhere, that's what I do. So I can facilitate this. And then most of them are certainly savvy enough to kind of work out that this might be moving into a new area in terms of, well, I don't normally do surgery, but they might try and put it together in a way which is, well, we're providing a package, but the surgery isn't part of it. And again, if you look at the Guardian article, I remember there was actually they cited a couple of different companies abroad that were doing this. So as you do, I was looking at them, scoping them out, stalking, call it what you want. And some of them kind of clearly had a better handle on this than others. And some of them were kind of at the outset trying to separate out the various elements or try to construct it in a way which would make it not look like a package. And to my mind, just doing a really bad job. Because it's very easy to do all these things and to sell them and to construct it in a way which is going to give, as you say, a claimant and their lawyers very easy in. And one of them we've already talked about, which is if you call it a package, you're kind of asking for it.
Well, exactly. That's what makes my life easier. But it's so important. I mean, we haven't touched on the consumer contract regulations, and I know the focus today is more on package travel because that's where we're seeing people call out more. What I should say is that on the point, just off the back of the point that you made, Matt, you can't contract out. Don't forget the PTR. You can't contract out of your obligations under the PTR. So it may well be that someone says, well, actually, I was just acting as an agent. I wasn't really doing this. If they fall within the definitions provided under the package travel regs, then they can't just say, well, actually, it doesn't apply to me. So people are often getting caught that way, I find, or I'm certainly saying to them in correspondence that this is something they need to be aware of, that they can't contract out of their obligations.
Yeah, very much so. And this is a lot of the work that we're doing at the moment. And we kind of, I guess we get onto this towards the end in terms of top tips and stuff, but there are ways to go about it and there are ways not to go about it. There's a certain amount of knowledge which is needed. To a degree, there's only so much you can do, because if you're operating in this sphere, look, you're either in or you're out. There is an easy way to avoid any liability and any issues whatsoever with this kind of area, which is to have nothing to do with it whatsoever.
Yeah.
But of course, as I say, it's an attractive thing for people to want to get into, because these things do seem to sit very neatly next to each other.
Yeah. I should say, Matt, we've had a comment from Constantine about a definition of medical tourism, which he's provided for us. And I should say, Constantine, thank you. If only if it was so simple with the courts that we could say, this is what it is, because that's the problem we have at the moment, particularly the fact that it's not defined in the directive, that we have a bit of an issue as to what it really means. But thank you for that comment. I should say, Matt, I'm conscious of the time. We've still got quite lots to do. Shall we whiz ahead to Clark? But I will just say, in terms of consumer contracts, as I said, it's something that we haven't touched on here. But bear in mind, if you don't fall within a package, there may be an argument available to you to fall within a consumer contract. But beware of those situations, and I touched on this very briefly. If you are dealing with a claimant who is an influencer, for example, or is having treatment that may be seen to be in the course of their profession, because they may not be found to be a consumer. So that's something, if you are acting for a claimant, you need to check quite carefully, because you might have someone like Matt coming at you afterwards and saying that you're not a consumer at all. So we thought we'd focus a bit on Clark and Kaczynski, because Clark is quite an interesting case, and it's one that I think is going to have quite some impact for all of us. For those of you that don't know about Clark, it's a case where Laura Clark, you can see in the picture, wanted to have cosmetic surgery. She found a clinic in Poland, and that clinic advertised online that surgeons would be UK trained and trained to the same standard as UK senior consultants, and they were UK registered with fluent English language skills. They also advertised consultations in the UK, and Ms. Clark had her consultation with Mr. Kaczynski, who you can see, and was assured he was registered with the GMC. And she contracted for breast uplift surgery and liposuction. She went to Poland, she had that surgery, it went wrong. She became very unwell afterwards and was admitted to hospital in the UK upon her return with sepsis, and she had necrotic tissue. Now, interestingly here, the fact that the defendant advertised that he was trained to a UK standard meant that the judge had no hesitation in finding that there was a term incorporated into the contract that he would operate to the same standard of a UK surgeon, and so that standard applied. And the expert evidence was that he'd fallen below it anyway, so there was no local standards evidence here. And the report itself, the expert report, was couched in such a way that it covered any surgical and clinical practice, whether governed by local customs or not. But there was, interestingly, no measurable difference identified between the Polish and English standards. And so you had that issue there. And then the judge, Foster J, said, I say nothing decisive on the applicability of tour operator cases to the concepts arising in medical negligence, but she thought they were inapplicable. So we have these two issues here as to when we're going to need local standards evidence in these claims. Are we going to need it at all? And also what we do in a situation where there is or is not a measurable difference between those standards, but also what specifically is in the contract. And I think this is quite a key point for claimants, because you can take from a clinic's website those assurances to say, well, actually, we're here dealing with English standards. We're not dealing with local standards in another country. So we're not dealing with Polish standards. We're not dealing with anything like that. These are English standards to be applied because they hold themselves out to be to that standard. So then you can specifically plead it and say that is English law contracts, standards are of English law. Here's why we say this, which I think is a much more difficult argument now for a defendant to have to deal with and face. But something Matt and I, we were talking about before, that what if you're in a situation where there is a measurable difference between those standards, you don't have those caveats there, then do you need local standards evidence or not? And I think you probably would.
Well, again, many of the audience today will be well aware of the whole issue around local standards and how, if we're ever going to fall out with each other over a drink in a bar at the end of the day, it's probably going to be over whether local standards good, bad, somewhere in between, etc., etc. Now put it in this context, wow. Okay, so the reason for that we could have got into Clark and Kalasinski earlier is that it goes straight to the heart of, what is the contract? Because in Clark, I think there were 3 defendants: the clinic, the surgeon, and I think the surgeon's insurer. It
was either clinic or surgeon's insurer, yeah.
So, to one point, more than one bite of the cherry there, but it should have been clearer, I guess, and probably the claimant will have said, well, we wish it was clearer. Throw into that a package tour operator as well. Maybe it makes things easier, maybe it makes things harder. But if you're going to sue a package tour operator, then I struggle to see how you don't reach that situation where you're not at least having to consider what the local standards are in the context of that medical treatment, because that's going to be important, come what may, whether it's the key fact. I know plenty of people would turn around and say, well, yeah, but you don't really see that in things like driving quality or safety issues. Basically, if someone's driving badly in Turkey or Poland or Australia, they're driving badly in the UK or America or anybody else, and I don't need local standards evidence to get me over that. But I just think this is it's always going to be more technical, isn't it?
Yeah, and I think if you're in a situation where you don't have any of these assurances made, that you can say, therefore, in terms of the contracts incorporated into the contract about the English standard for care applying, the problem that I have is when you look at cases like Lockheed on the beach, there's references there to egregious, blatant, life-threatening negligence where local standards are irrelevant. So do you fall into that? And I think there won't be that many cases that do fall into that, to say that actually local standards therefore are irrelevant. And so you probably then would need evidence of local standards, I would think. I'd be certainly for a claimant suggesting that you would need that evidence, because you might then come to trial and a defendant says, well, look at Lockheed, this doesn't say that. You're not in that situation. You should have local standards evidence, which was a point made here, hence why this whole issue came up. But I mean, obviously the judge got around it in the sense of, well, there's the standard of care was incorporated into the contract. But if you're not in that situation, then the matter's a bit more complex. I would be saying that you probably need local standards evidence to cover your back.
Yeah. And I think, if you and I had one of these cases now, whether we're working together on other sides, I think we would certainly be suggesting that we get that evidence, whether or not it gets used formally, just to see what it says and see how it all starts to pan out. Yeah. It's an interesting one, isn't it? Because more so than in many, well, no, that's fair. But the point I'm trying to make here is no one is trying to leave, in this case, Mrs. Clark in the situation she ended up being in, But I don't know. I mean, I'm well outside my usual sphere of expertise talking about pure clean neg. But like the point is, if you have 100 surgeries on something, something is going to go wrong on one of them, isn't it? Isn't that kind of just part and parcel of it? Which is there's no guarantee of success or that something won't go wrong. Then you're into the realms of assessing whether or not that is, right, wrong, negligent, etc., etc. But how is that normally assessed?
And we've just had a chat from Victoria. Hi, Victoria, saying with RTAs abroad, we're saying surely everyone knows how to drive properly. There's no such thing as different standards there. And you're right. It's an interesting one. I mean, what we have to bear in mind here, we've got issues of law and standards. And I think because these operate as essentially clin neg claims that are cross border, so they're both travel and clin neg. And so we have to look at standards of care as we would in a clin neg claim, but within this whole context of it being cross border. And so it's difficult because also when we're looking at things like here, we're obviously focusing on the issue of standards, and we've talked a lot about contracts. You could bring a claim in contract, in tort, or in both, and the law may be different in them and the standards may be different in them depending on what you're arguing, because you could have a situation where you say there's a contract and the English standard of care applied, it was incorporated, but in tort the standard is that of Turkey. So you're dealing with multiple issues where your law and your standards may be different. So it's just a bit of a faff, but it's so important to get this right from a really early stage, and you have to deal with it and think about it really early on, because it's going to affect the way that you plead the claim, that you're going to carry it forward, and naturally how the defendant's going to defend it. Because as I said earlier, if you take Clark at face value and you think, well, I'm not really going to need local standards evidence, but you don't fall into that category of the blatant, egregious, life-threatening negligence, you're going to have a situation later where you're going to be derailed, I think, and the court's going to say, well, you need it. I suspect the defendant will make that argument.
Yeah, no, I agree. I mean, so complex. This is a law school exam question, isn't it?
Oh, it is. It is. And Daryl said that the local standards may not be an issue with regard to the physical surgery, but may be more of an issue in the aftercare where standards may well be different. And I think that's right. It's not often that I see really any difference with the physical surgery side of things, although I'd never speak too soon because it depends on where you are. But in terms of aftercare, I find a lot of cases that concern poor aftercare or negligent aftercare really hinge on this issue of standards. That's where it becomes really relevant. So I think it's something certainly that you need to be very aware of if you have a claim like this. As I say, it's not really often in terms of the surgery itself, although you'd be surprised. There are the odd cases where that may be the reality, but it's more often with aftercare. I don't know if that's your perspective, Matt, if it's more those aftercare claims that you see.
It's a little bit of both. I mean, sometimes it's hard to say, isn't it? I mean, trying to think back to the case, Mrs. Clark was not right almost immediately after waking up, as I recall. And
yeah, she was very, very unwell. She
so
came very unwell very quickly.
Yeah, and it is, and again, as I recall, it was said, I don't know whether this is true, but the clinic and the doctor wanted no aspect, you wanted nothing to do with the aftercare. They very much saw it as we're done, not our problem.
Yeah, they couldn't get the surgeon to come in, or he was supposed to be coming in and didn't. And
that's right.
There were all issues like that. And if I remember rightly, her parent was a nurse or a medical practitioner, so picked her up, checked her obs when she got to the airport, and took her straight to A&E, and that's when she had her sepsis and diagnosed. So it's certainly a different situation to others that we may see in these sorts of claims, because not everyone's going to be in that situation. But certainly a case to have on your radar.
Although, again, looking behind the kind of FCDO, going back to that point again, they're clearly seeing this. They're kind of saying, look, people are going abroad immediately, kind of getting back into Heathrow, Gatwick, Manchester, or whatever, and going straight to hospital because something is not right. So they're adding to the burden of the NHS. Obviously, they're not well, but that's the context. So they're obviously seeing that kind of problem. But I accept it's not always going to be apparent that quickly.
Yeah, absolutely. And we wanted to talk, we touched on this a bit already, so I'm conscious of the time, about things that claimants and defendants need to think about. And you will see, in the spirit of Eurovision, I put Daddy Freer's think about things on the slide for us all to think about in these cases. And I think from a claimant's perspective, from the very outset, I'd certainly be telling people to be thinking about what law applies, what standards apply. Are you looking at a claim solely in contract? Are you looking at a claim solely in tort, or in both? Are the law and standards in respect of those different? Who are your potential defendants, and are they viable? Because I tend to find one of the big issues is that actually who may be the appropriate person to sue may not have any insurance. And we go back, essentially, we circle back to the point we made about the PTR earlier, that there are provisions within the package travel regulations about insurance and the like. And if you don't have what you should do, there are criminal sanctions under those. So things like fines, for example. Now, if you're dealing with a claim and you have no way of getting any compensation out of that defendant, it's going to be tricky to get off the ground, even if it's a slam dunk, and it's something you need to look at. Sometimes it's helpful to look at Companies House or do some investigations. Do they have a clinic here? Because when they do their consultations here, they may have some affiliated link. It comes back to the consumer contract point, to see if there's any way. And you may then think, well, actually, surgeon can come in as well as clinic because one of them's got more insurance than the other. The problem is that you then have to think about the cost consequences of that, because if you're bringing someone in unnecessarily who's eventually going to have a claim dismissed against them just to protect yourselves in terms of insurance, then again you expose yourself to cost risks and you don't really answer the first question. So it's really important to work out who you need to sue and whether there's going to be an opportunity to get compensation at the end of it, because it could be all well and good that you go through the court system and the claimant's left in no better position. So I think that's really, really important. And also gathering as much information as possible. And I tend to find it can always be really hard in a cross-border situation such as this, because often with these claims, you may have a consent process that essentially takes place on WhatsApp, or you might have the odd Instagram message that seems to formulate the contract. There might not be a physical contract in existence. So you're trying to piece together things as best as you can, which can be quite tricky in the circumstances, and trying to work out, therefore, where do you stand on law and standards, and what does it say, and is there anything in there that says about jurisdiction, for example, which we haven't really even touched on. And I have seen consent forms that seem to act as a contract. They'll say, oh, you consent to this treatment, but by the way, it's Polish jurisdiction that apply. If you want to sue us, you need to sue us in the courts of Poland, which again, there are arguable issues there as to whether that's really a consent form and whether someone's had appropriate essentially warning of that moments before going to an operation. So I think it's really important to look at those issues. We did have a question before, I think it was from Victoria, about pre-action disclosure applications. The problem that you may have is if someone's a likely party and you need to get disclosure from them, it shouldn't be too much of an issue. If they're not a likely party, say you want operation records or something and they come from the hospital and the hospital's not a likely party, you're probably going to have some real difficulty with that, because I think you're more than likely to have real difficulty with that because you can't get a PADA against a non-party. So then you'd be looking at a situation where once proceedings are issued, then you can go and get a third-party disclosure order. But I think I've just seen there's another chat. And so it's just from Constantine about EU cross-border directive law coming into this. And Constantine, this is just where we're talking about package travel regulations and the like earlier, and depending on the law that applies to your claim, depends on how things are going to work, because you may find you have all the ingredients to essentially try and bring a claim here, but the court may not side with you in terms of jurisdiction and may say, well, all the witnesses are abroad. The only witness here is, say, the claimant, all the evidence, well, you need translators, that sort of thing, that maybe England's not the appropriate forum for it, particularly if the case is one where English law doesn't apply. So that's when we're getting into a territory of looking at different laws, or indeed if it's a package travel case, you look at the package travel regulations and the directive that precedes it. But I don't know about you, Matt, in terms of, I don't know if there's similar things that you think that defendants need to think about or not.
Yeah, to a degree, they need to think about all of that. I mean, as I mentioned earlier on, there's nothing wrong with working in this space. So if it's something that you want to do as a UK tour operator or otherwise, fine, you just need to get your ducks in a row. And what you will want is, you will want to be clear from the outset that you understand what the potential implications here are. Now, if we're going to jump straight to a situation where we've bypassed any number of interlocutory hearings and established that, surgery is, part of a package, it's a tourist service, it's a travel service, etc., etc. Or we just accept that it's part of a package. That's more likely, isn't it? Well, then you do the things that any tour operator does, which is you just make sure that if you're going to be responsible for the acts and omissions of your suppliers, you have a damn good contract, an agreement with them, which will indemnify and cover, and that all the necessary insurances are in place, yours and theirs. And on paper, that's very easy to do. In practice, sometimes it doesn't seem that easy, does it? So that's easy enough. And as I say, there are going to be plenty of people that will say, I can make this work for consumers. I can make it work for me, make money, give them a service. Everybody's happy. And if the suppliers are on board with that, and the clinics and the surgeons, however it's going to be structured, are on board with that, no problem. Otherwise, you need to be very clear about what the lay of the land is to make sure that you are not sitting in that. So again, you might, as a travel business, Matt Travel, based in Leeds, my specialism is taking people to Turkey because I know I can get flights with, the various airlines that will serve from UK airports to the various airports in Turkey where it's going to be, and I can get accommodation with local, places which are perfect, suitable, near the treating clinic, have good aftercare facilities in the sense that it's not like they're performing the aftercare, but it's where you want to be if you're going to stay there for a week or two. So I can do that, but I'm having absolutely nothing to do with the actual surgery. It's like almost there if you've otherwise arranged your surgeries on. Because if you go into Turkey, you're going to need to get there, right? So there's nothing wrong with having that separation, but you've got to be so careful for all the reasons we've set out to stay clear of that. And I don't think that in itself is a particularly attractive proposition anyway. But at the end of the day, if there's lots of people going from Leeds Bradford to Bodrum or something like that because there's a particularly good clinic out there that's getting a lot of business, well, you might be in on that. But either way, standard lawyer advice. Make sure your contracts are well drafted, make sure they're clear, make sure that you understand what they mean, make sure that your partners of whatever distinction know what they mean, and that they will stand up. And again, from a claims point of view, it's the indemnity, it's the passing through of liability, etc., etc. If you have those things in place, all good. But again, how many times have we said that in a normal package travel situation down the years, only to find out that when push comes to shove, the whole thing just falls apart.
I was going to say, Matt, that Victoria said it sounds like Matt Travel sounds like a very respectable cosmetic surgery package company.
Available to purchase. Just saying, Victoria. Got it all done, trademarks, the whole lot.
Now, I was going to say, does anyone have any questions for us? Before I'm doing a bit of shameless plugging here, I've written a book on this very topic if any of you are interested, and we're having a party to celebrate in Chambers. So you need to just contact Emma if you want to come and join us for some fizz, just because I don't know what numbers are at the moment, and she may be annoyed at me for putting it on there. I'm hoping she isn't, in case we get overwhelmed. But hopefully, if you, of course, are interested in this topic, it's a good idea to learn a bit more about it, and you want to grab a copy or indeed join us. But otherwise, if you have any questions, please do let us know. We've still got 10 minutes now for questions, if anyone has any. But it's certainly something I think is just a really kind of topical conversation that I think we all need to be thinking about, because I just think these claims are going to be kicking off left, right and centre, really.
It does. By the way, I don't have a book, everybody. It does feel that way. Again, we think we're seeing a trend that if you're plotting it on a graph, all right, it's maybe not going to be the next flight delays or illness claims, but it feels like there's a kind of trend there because it's happening more.
Yeah.
And as a factor of volume, you're going to see things. And again, the potential for this to go wrong is there. So it's important. I've got one slight point to add on the disclosure point from earlier on, which was it's going to come up in this context if there is a package organizer or a potential package organizer there, where you have to disclose the medical records. It's like, so we see this again just in terms of, again, normal claims, people looking for disclosure from tour operators for medical records. What makes you think that the tour operators have got them? the hospitals, the clinics are not going to send anything to the tour operator, and the tour operators are not going to ask. So that's something I see a lot. And we end up going back and saying, I don't know if you think there's something going on here, but we don't have the medical records for this person. Why would we? We don't want them, frankly. Is it in their control? Well, we've had this argument. I think I won, Nick. Maybe. Well, maybe. I have issues with the whole control thing, because it's like I think that's a bit safer. They're certainly not going to be. I mean, look, if the clinic did, or somehow the tour operator did just get sent these documents, and again, that may or may not have happened down the years. Yeah, they're in possession, they're in control, and you would have to disclose them, no questions asked. But generally speaking, I think I'd win that one, because we would say, what makes you think we've got any control over an independent clinic to get these documents? If we ask for them, aren't they going to say no? Patient confidentiality, they shouldn't they? From my point of view, is the last thing I want them to do is to say, yes, here you go.
Well, Nick says it's an argument.
Well, it is an argument, and again,
it definitely is.
We've definitely had plenty of, and I don't recall the specific case, but I'm sure me and Nick down the years would have talked about, what constitutes control for that particular part of the CPR. But it is arguable.
And we've just had the point raised that surely there'll be a contractual clause between the tour operator and clinic, which means the clinic needs to provide full documents.
Yes.
What claimants will be saying.
Well, this is effectively, again, don't want to put words in Nick's mouth, but I think this is effectively Nick's argument, because it's what you see in a, again, normal tour operator contract, which is your supplier agreement is going to have some kind of, you would think, indemnity and kind of liability, but also assistance clauses. You have to help us investigate, you have to give us documents, etc., etc. So does that constitute control? I've always thought that the reality of the situation should be the more important factor, which is, yeah, we may have that right under the contract, but if the hotel, the airline, the supplier, the clinic refuses to give it to us, then we don't have control after all, as it turns out. But I take the point.
We've just had a question asked about sharing the recording of the webinar. I should say that this is all going to be recorded. Well, it already has been recorded. It'll be put online as well. So I think you will be sent a copy of it. But if not, it will be on our YouTube channel. So don't worry, you won't miss anything. I think, but looking at the time, I think that's it. But it's been so lovely to chat to you all. Thank you so much. And obviously, you've got our email addresses if you've got any questions for us both. But thanks again, Matt, for coming. It's been lovely.
My pleasure. Thank you very much for having me. I enjoyed it.
Anytime. All right. Well, take care, everyone. Have a good rest of the day.
Yeah, you too. Take care, everyone.